All right, everyone, we're ready with our next presentation. Let me introduce Lauren to you. Lauren Mendelsohn is a junior partner, just recently, congrats, at the law offices of Omar Figueroa, one of the leading cannabis, hemp, and psychedelics law firms in California. Her current focuses include permitting and licensing, regulatory compliance, business formations and transactions, intellectual property, administrative hearings and appeals, and policy work from drafting to analyzing to advocating for various pieces of legislation. Lauren formerly chaired the board of directors of Students for Sensible Drug Policy, an international youth-led nonprofit organization, and more recently served on the board of the International Cannabis Bar Association. Currently, she sits on the board of directors of California Normal and the Sonoma County Cannabis Alliance, and is a chapter leader for the Sonoma County chapter of the American Civil Liberties Union of Northern California. Lauren, take it away.
All right. Thank you, everyone, for being here today. And I'm going to be talking about the Medicinal Cannabis Patients' Right of Access Act, which was passed as Senate Bill 1186 last year, and how jurisdictions and businesses and also individuals can prepare. So next slide. This is just a quick disclaimer. So I'm an attorney, but none of this is legal advice, and there is no attorney-client relationship that is formed just because you listen to this webinar, seminar. Please be sure to speak with an attorney and get some specific advice for your situation before acting on anything. And please note that while we've tried to have this presentation be up to date, if you're watching this in the future, it's possible that some of this information may not, again, be accurate at that time. So we're a room full of attorneys, so this should all be pretty standard. Next slide. And you just read my bio, so we can skip forward again. So why don't you, don't go to the next slide yet, but if you just kind of click through, you're gonna, yeah, here's our outline. So you can make all of these appear. So, so yeah, that's fine. Okay, so click, so we're gonna talk about 1186, the background, then what does the law say, then implications for jurisdictions, implications for businesses, implications for patients and caregivers, and then we'll hopefully have some time for some Q&A. Okay, next. So here's a map of the state of California and where cannabis businesses are allowed and not allowed. And this particular color-coded map on the side, I have this set to retail establishments specifically, and I pulled this as of earlier this week. And so there are 60% right now of the county, of this state, prohibits retail establishments, and 40% allows it. So you can see less than half the state actually allows access to retail, which is what's important for what we're talking about right now, which is access for medical cannabis patients to be able to get their medicine from a licensed establishment that is close enough that they can either drive there or have it be delivered to them. And so this is straight from the DCC's website. They have this map and they update it pretty regularly. Next slide. So these are some just some more tables that show just how many dispensaries there are, like per capita, and also licenses both in the some different counties here in California, as well as California compared with some other states. And the purpose of these is to show that they're compared to, considering the size of California, we do not have enough licensed retail establishments to really properly serve the adult use and the medical patients that are here, which is part of the reason that the illicit market is still thriving. Next slide. So some background on SB 1186. So the local control provisions that were baked into Proposition 64 have resulted in a lack of access to licensed cannabis retail outlets. So, and by local control provisions, what that means is under Proposition 64, Malcursa, cities and counties in California may choose to, they have the ability to regulate commercial cannabis establishments within their borders, including choosing to prohibit them outright if they wish to. Now with a big caveat, thanks to SB 1186, which we'll get into. So this has been inhospitable for consumers, patients, legal businesses, and communities. And non-storefront cannabis retail, otherwise known as delivery operations, these have a minimal impact on the surrounding area while still serving an important need. And many of these places, when they're banning or choosing to heavily regulate different types of cannabis businesses, one of the arguments that they will put forward is the significant impact that it'll have either on the environment or on traffic or on safety. And so with a delivery operation, you see less of that being an issue. And so that's one, that might be local governments should be able to stomach this a little more than perhaps a large grow or something like that, or a storefront dispensary. So in 2022, Senator Scott Wiener introduced SB 1186. And this it both amended and added some language to the California Business and Professions Code. And it was supported by a number of patients' rights groups and cannabis organizations, including California NORML. We were lobbying for this. And it was adopted and signed into law September of 2022. And it just went into effect January 1st of 2024. So local governments were on notice for a whole year that they had to get into compliance with this. Next slide.
I'm trying.
Oh, sorry, that last bullet point just said that there was the key provisions went into effect January 1st. Okay, so now what does the law say? So the next few slides, we're just gonna read through it. I can't remember if it's the whole thing or most of it, but we're gonna read through it together. It's not too long. So the Medical Cannabis Patients' Right of Access Act, which has been codified now at section 26320 of the Business and Professions Code. And so this says that the legislature finds and declares access to medical cannabis is an integral aspect of access to health care. Eliminating barriers to medical cannabis access is essential to preserving and promoting the health of Californians for whom physicians have recommended the use of cannabis or cannabis products. And it is the policy in the state and intent of the legislature to ensure that Californians throughout the state have timely and convenient access to safe, effective, and affordable medical cannabis. Next slide. The act shall be known as the Medicinal Cannabis Patients' Right of Access Act. And then it goes on to define some key terms. They define here what medical cannabis means, medical cannabis business, medical cannabis patient, and those will be important to refer back to. We can go to the next slide. I don't need to literally read through the whole thing word for word, but I'll try to summarize here. So, but this is one of the key provisions right here. This says that a local jurisdiction shall not adopt or enforce any regulation that prohibits the retail sale by delivery within the local jurisdiction of medicinal cannabis to medicinal cannabis patients or their primary caregivers, or that otherwise has the effect of prohibiting the retail sale by delivery within the local jurisdiction of medicinal cannabis to medicinal cannabis patients or their primary caregivers by a licensed cannabis business in a timely and readily accessible manner, and in types and quantities that are sufficient to meet demand from medical cannabis patients within the local jurisdiction, including but not limited to regulation of any of the following that has the effect of prohibiting the retail sale by delivery of medicinal cannabis. So here's some examples of things that they cannot do. They cannot restrict the number of medicinal cannabis businesses authorized to deliver medical cannabis into the jurisdiction. They cannot restrict the operating hours if they have the effect of essentially prohibiting that. They can't restrict the number or frequency of sales by delivery of medicinal cannabis, or the types or quantities of medicinal cannabis authorized to be sold by delivery. And this one is, I think, the most important one, the establishment of physical premises from which retail sale by delivery of medicinal cannabis within the jurisdiction is conducted by a licensed non-storefront retailer, except that this paragraph shall not be construed to require the establishment of additional physical premises in a local jurisdiction that allowed medicinal cannabis retail as of January 1st, 2022, and which has at least one physical premises engaged in the retail sale of medicinal cannabis, whether storefront or delivery. So what this is saying is that if you had even only, a storefront dispensary only as of January 1st, 2022, you'd be okay. But otherwise, they can't, jurisdictions that have previously banned either specifically retail by delivery or all types of commercial cannabis, they cannot do that anymore. They cannot restrict medical cannabis business from having a physical premises in their jurisdiction that is where they have their license to conduct delivery from. Next slide.
I have a question on that, but we'll get back to that, I guess.
Okay. And nothing in this chapter shall be construed to prohibit the adoption or enforcement of reasonable regulations on retail sale, including but not limited to reasonable regulations related to zoning requirements, so they can still have zoning rules about where these can and can't go, security or public health and safety requirements, licensing requirements, the imposition, collection, and remittance of applicable taxes, regulations consistent with requirements or restrictions imposed on cannabis businesses. So they can still apply normal types of rules to them. Nothing in this chapter shall be construed to limit or otherwise affect the ability of a local jurisdiction to adopt or enforce any regulations on commercial cannabis operations other than retail sale by delivery of medicinal cannabis. So again, this is only for medical deliveries, and that became operative just earlier this month. Next slide. Now, how is this going to get enforced? This chapter that may be enforced by an action brought to pursuant to Chapter 2, commencing with Section 1084 of Title I of Part 3 of the Code of Civil Procedure, so i.e. a mandamus action, by any of the following parties who shall be beneficially interested within the meaning of Section 1086 of the Code of Civil Procedure. So these are the types of people that can sue. A medical cannabis patient or their primary caregiver who seeks to purchase medical cannabis or medicinal cannabis products within that local jurisdiction. I qualify, I'm a medical cannabis patient, and I might want to buy weed there. And the next one, a medicinal cannabis business that seeks to offer medicinal cannabis for sale within that jurisdiction, whether or not they're already located there. You have a dispensary in some other city, you want to allow delivery there, you have standing to sue. The Attorney General, or any other party authorized by law. We'll see it, that's kind of TBD what exactly that would mean. But the point is, this is very broad. And this section shall not be construed to limit the availability of any other remedies available. And this became operative also earlier this month. Next slide. And nothing in this chapter shall be construed to otherwise affect the ability of a local jurisdiction to regulate adult use cannabis. And also this chapter is a matter of statewide concern and not municipal is fair. So next slide. So that was, that's what the law says. So what does this mean? So here's implications for jurisdictions. Hold on, go back. So they must allow non-storefront cannabis retail businesses to actually exist there and be based there by January 1st, 2024, or face potential lawsuits. Many jurisdictions may need to amend their municipal codes, and that is still the case, as you saw from that first slide. 60% of the state is in violation of this law and is could be sued. Why? There's a wide range of regulatory options here if they're deciding what to do. They could just allow medicinal cannabis delivery, but they could go beyond that. They could also allow adult use cannabis delivery. This could be an opportunity for them to finally regulate storefront dispensaries or other types of cannabis businesses, and maybe something like lounges and events. Or as I noted, they could just do the bare minimum and allow storefront or non-storefront delivery rather. There were grant opportunities last year from the state to even help local jurisdictions come into compliance with this. The state was giving out money to help them redo their ordinances. And that I believe that might open up again. Next slide. So this was about that grant program. February 2023, they announced it. And if you were a local jurisdiction that didn't have a cannabis retail licensing program but plan to adopt one, then you could apply for this grant. And the idea was to help, both open up more storefront and non-storefront retail outlets to meet the demand and also combat the illicit market. So they had that initial grant window open last spring, and then according to their website, which actually I double checked the other day just to make sure this was still happening, they are hoping to open up another grant round in the future. And there's a link where you can find out more. So that's some implications for local jurisdictions. What about implications for businesses? So I think there's one more bullet point on this slide. Yeah. So currently licensed M retailers now have standing to file a lawsuit against any jurisdiction that prohibits medicinal cannabis delivery only retailers from operating there. And that's because the language of the statute said a medicinal cannabis business that's interested in serving patients there. So I think my interpretation of that is that they shouldn't just be an adult use retail licensee. They should really be a medicinal or a medicinal on adult use retail licensee. and also other businesses interested in offering deliveries in a jurisdiction. But they should consider engaging in communications with that jurisdictions about how do they amend the regulations to allow them to operate or get ready to engage in that litigation. Next slide. And what about for patients and caregivers? What are the implications? Well, medicinal cannabis patients and the primary caregivers also now have standing to sue if they want to purchase medical cannabis in a particular jurisdiction that doesn't allow it. And do make sure that the recommendation is current because the standing is only granted to current patients. Now, for attorneys in the room, well, what is important for you and us to note, and also for clients to be aware of, is that there's a potential for attorney's fees here. Upon a motion, a court may award attorney's fees to a successful party against one or more opposing parties in any action which has resulted in the enforcement of an important right affecting the public interest. There's a few more bullet points here. So the California Code of Civil Procedure, section 1021.5 says, upon motion, a court may award attorney's fees to a successful party against one or more opposing parties in any action which has resulted in enforcement of an important right affecting the public interest if a significant benefit, whether pecuniary or non-pecuniary, has been conferred on the general public or a large class of persons. That's A. B, the necessity and financial burden of private enforcement or of enforcement by one public entity against another public entity as such are to make the award appropriate. And C, such fees should not, in the interest of justice, be paid out of the recovery, if any. Here are there more bullet points. Yes, this is the codification of the private attorney general doctrine and complements the equitable doctrine under California law that had been developed prior to the adoption of this civil code section. So the California courts can also exercise their inherent equitable authority to award fees to petitioners who successfully pursue public interest litigation that vindicates important constitutional rights. See Serrano versus Priest, the citation is there. The purpose of this is to encourage suits that enforce a strong public policy and benefit a broad class of all people. The inherent equitable authority may be invoked when fees are not available under the statute. See, for example, Best v. California Apprenticeship Council, citation is there for you. And the essence of that says that fees may not be awarded under section 1021.5 for administrative proceedings that do not result in court actions, but they may be awarded under the equitable private attorney general doctrine. And the courts have taken a broad view of who is the successful party in such a case. It's limited only by the express statutory limitation that public entities are not eligible for the award unless they successfully prepared over another public entity. Generally, a party is successful if it achieves some relief from the conditions challenged in the petition or litigation. And see Maria P. versus Riles for that. And similarly, the courts have taken a broad view over what any action means. See the Inree Head case. Okay, I tried to get through that pretty quickly. Do we have, but I think we're also still running, getting a little closer. So what about questions? I'm happy to answer some questions if anyone has them.
I have a question. I love your broad interpretation of the law. But what I'm seeing is there are some jurisdictions that are moving to change their ordinances. Some jurisdictions have made it illegal even for entities to deliver into their city or county, I think. Mm-hmm. And so the language in 1186 that talks about something about timely and readily accessible delivery, there was one jurisdiction in Southern California that was arguing, well, since there are nearby jurisdictions that will deliver into our city, we don't have to allow a delivery service to be located in our city. We just have to allow deliveries to come in, and oh, by the way, we want to tax those, is what a lot of jurisdictions are moving to do, regardless. So is your interpretation of the law, from what I'm understanding, you're saying that cities and counties have to allow a standing delivery service within their borders, or can they get away with just allowing medical deliveries from outside their border if it's determined somehow to be timely and whatever the language was.
Yeah, my interpretation of this is that they have to allow them to actually be existing within their borders. And that is that's how I believe this is that's clearly the intent of the language. And I believe that I've read it a number of times. That's how I'm interpreting it. And I'm eager to test it out and hopefully the courts will agree with that.
Okay. Any other questions? Let me check the Q&A on.
Yes.
Yeah.
Medical marijuana is subject to potential city tax if necessary, also through the gross receipts taxation process on a business. It's also subject to excise tax regardless of whether or not you have an MMIC. And only if you have an MMIC are you exempt from paying sales tax. But if you only have a doctor's recommendation, you are not exempt from paying sales tax. It does change how much weed you can carry on you.
That's correct.
Oh, so you could hear that well. Okay, I'm glad to hear that. I am so
Yeah,
glad.
I can hear the room. I can hear in the room very well. So
Now we can see you.
Oh, yeah, and if I can get it better, then I can, we can really see her. Yeah, okay, here we go. Okay, great. Well, I had a break scheduled. If there are no other questions, wait, I just want to make sure there aren't any Q&A from the Zoom call. No.
Can we give a proper round of applause to Lauren for making partner, please?
Yeah.
thank you. Appreciate that.
We're all proud of you.
Actually, well, I just have a comment from Zoom. An activist, Candace Hawes from OC Normal, said she's already had a council person reach out to her about it. And so thank you for that presentation, Lauren.
I have
So-
one question.
Yes.
Cities or other jurisdictions can obtain some funding from the state if they apply for a grant to change their ordinances. What is the amount of that grant that they can receive, or what is history showing the amount to be?
It's gone. It's not open anymore, right?
That it will be opened again later this year, she said.
Yeah, they're planning to open up another grant round, but I don't know exactly when. I would check the DCC website. They have a page about this.
You happen to know the dollar amounts?
I don't recall the dollar amounts off the top of my head. I think it's dependent on how much that there is earmarked for it in like a state funding. So they're gonna wait on that. And then it's also gonna depend on well, yeah, I think that's what they're waiting on. So check the website. That'll be available. And then I see another question from Michael Chernus. Why is the right to sue limited to licensed retailers? Let's see. I would have to go back to the slide that pulls up the language, but there is something in the language that talks about how medicinal cannabis, don't recall if it says retailers or businesses, but I think the point is that if you have an existing business and you want to sue, then you would likely not bring a suit if you were an unlicensed business for various reasons. So I just think it makes most sense that if you are going to actually exercise that you be a licensed medical business. And the language does specify a medical business there. So hopefully that answers your question.
Yeah.
Is the BOT tax have to be paid from an entity outside of the jurisdiction that it's delivering to?
The what tax?
The BOT tax?
Business operating tax.
Does the business operating tax have to be paid by whom?
If you're an entity in a city, you're delivering to another entity, another city that doesn't have an ordinance, you still have to pay that business operating tax. Sacramento has a 5% tax.
So if you're an entity delivering into a city, do you have to pay their BOT tax? Even if
You'd
you're
have
not
to look at
located in the city?
It's likely it might be very dependent on that particular local jurisdiction's ordinance. I would want to check the language for both cities and see if they had their own special cannabis tax and whether or not they were it applied to just businesses there, or in some cases I have seen it where they try to also apply that to businesses that are delivering to there. I'd check that. I'm not a tax expert, so I think that's a question. It's a good question, but start with checking the tax ordinances in both jurisdictions.
Whoever asked that, and really interesting case study, want to check out and make your brain break about apportionment of taxes is the city of San Diego. They have like a really complex formula about how much business your business does within and without this, within and outside of the city's borders. And there's a percentage that's applied and all kinds of things, and it's in response to other cities increasing tax rates outside San Diego. It's fairly effective at making your neighboring city non-competitive for your residents. So if, for example, city A has a tax of 5% and city B has a tax of 2%, if you come in, now that consumer is paying 7%. As opposed to if you order from someone within the city who may only be subject to 2%. Now, we're double taxing the consumer, making it less competitive for them to purchase their cannabis goods outside of the city. We tried to deal with this a lot in Orange County, and it was, like I said, it'll make your brain break if you want.
Okay, well, I think we've got to wrap up this panel. I did have a little 15-minute break scheduled here. So why don't we just take 5, stand up and stretch for a minute, and let me set up the next thing. We're going to have Hurst Jane coming in speaking about new law or local licensing progress and obstacles. And then Lauren's going to come back and speak about cannabis lounges and events.
Can someone hear, can they hear me on this?